For generations, the American public has been conditioned to believe that federal power flows in one direction, from the top down, from agencies to citizens, from authority to obedience. The idea that the system could ever turn inward, that the machinery of enforcement could be aimed at itself, has always been treated as unthinkable. But history shows that every empire reaches a moment when the rules it imposed on others finally come back around. Behind the scenes of the U.S. justice system, judges do not command armies. They do not carry weapons. Their power exists entirely on paper. And yet, that paper is supposed to be absolute. A court order is not a recommendation. It is not a political statement. It is the law itself speaking. And when a federal judge issues an order, every agency, no matter how powerful, is legally bound to comply, including the FBI. Now, imagine a scenario so extreme that it forces the system to reveal its true hierarchy. A judge determines that the director of the FBI has willfully defied the court, not through a misunderstanding, not through a technical error, but through deliberate refusal, contempt of court, obstruction of justice, or failure to comply with a lawful order tied to an ongoing investigation. In such a situation, the judge has only one option left: escalation. An arrest order against a sitting FBI director would not just be rare, it would be almost unthinkable. Not because it's illegal, but because of what it would expose. It would confirm that even the most powerful law enforcement official in the country is, in theory, just another citizen under judicial authority. And that realization alone would send shockwaves through Washington. If the order were issued, the responsibility to execute it would not fall to the FBI. It would fall to the U.S. Marshals Service, the enforcement arm of the federal courts. Their loyalty is not to agencies. It is not to the executive branch. It is to the judiciary. Their mission is simple: enforce the law, regardless of who stands in the way. In this hypothetical timeline, the clock would start ticking immediately. 48 hours. That's the kind of window courts give when they expect resistance. A final chance to comply, a final chance to avoid escalation. And once that window closes, the process becomes mechanical. No politics, no negotiations, just enforcement. The implications would be enormous. Internally, federal agencies would be thrown into chaos. Who gives orders when the top official is suddenly subject to arrest? Who controls classified information? Who decides what is protected and what must be surrendered to the court? Power struggles would erupt instantly, not in public, but in locked rooms and emergency meetings. Externally, the public narrative would fracture. Some would call it accountability. Others would call it a coup. Media outlets would split along ideological lines, each crafting a version of reality that fits their audience. One side would frame it as proof that no one is above the law. The other would frame it as judicial overreach, a dangerous precedent that threatens national security. But lost in the noise would be a deeper truth. This kind of confrontation does not happen overnight. It is the final chapter of a long, quiet war between branches of government. These battles begin with sealed motions, ignored subpoenas, redacted documents, and private warnings that never reach the public. By the time an arrest order is even considered, the relationship between the court and the agency is already broken beyond repair. Legal scholars have long warned that democracies do not collapse from the outside. They collapse from internal contradictions, from institutions that grow so powerful they forget who they answer to, from systems that enforce the law aggressively against the public, but reluctantly against themselves. And this is where the scenario becomes truly dangerous. Because if a court order of this magnitude were ignored, the consequences would be catastrophic. The judiciary would be exposed as powerless. The rule of law would be revealed as conditional, and every future court order would carry an unspoken question. What happens if the target simply says no? On the other hand, if the order were enforced, it would shatter the illusion of untouchable authority. It would send a message that even the highest offices are not immune. But that message would come at a cost. Trust would collapse. Markets would react. Allies would question stability. And enemies would watch closely, searching for weakness. This is why moments like this, even as theoretical scenarios, terrify those in power. Not because of guilt, but because of precedent. Once the line is crossed, it can never be uncrossed. Once an agency head is treated like an ordinary defendant, the entire hierarchy of federal authority is rewritten. In the end, this isn't about one judge, or one director, or even one agency. It's about whether the American system still believes in its own rules, whether courts are willing to enforce their authority when it becomes uncomfortable, and whether institutions built to uphold the law are prepared to submit to it when the spotlight turns inward. Because the most dangerous moment for any democracy is not when criminals break the law. It's when those entrusted to enforce it decide they no longer have to follow it. And once that line is crossed, it doesn't announce itself with chaos. It doesn't arrive with sirens or headlines. It settles in quietly. Court orders begin to lose their weight. Oversight becomes performative. Accountability becomes selective. The law still exists on paper, but its force depends entirely on who it's aimed at. Downward, it is absolute. Upward, it becomes negotiable. This is how systems rot without collapsing. Not through rebellion, but through exception. Through the slow normalization of the idea that certain offices are too important to be questioned, too sensitive to be constrained, too powerful to be touched. And once that belief takes hold, the law stops being a shield for the public and becomes a weapon of control. History offers a clear warning. Every democracy that failed did so only after its institutions decided they were indispensable. Only after enforcement became detached from accountability. Only after authority stopped fearing consequences. At that point, elections still happened. Courts still operated. Laws were still passed. But the outcome was predetermined, because the rules applied only to those without power. This is why confrontations between courts and enforcement agencies matter so deeply. Not because of personalities, but because of precedent. Either the law remains supreme or power does. There is no third option. And once the balance tilts, it rarely tilts back without cost. The public may never see the meetings where these decisions are weighed, the closed-door arguments, the warnings issued quietly, the calculations made about optics, backlash, and stability. But the effects are always felt. Trust erodes, cynicism grows, and eventually, people stop believing justice exists at all. And when that happens, the damage is irreversible. Because a system without belief doesn't need to be overthrown. It simply empties itself. Authority remains, but legitimacy disappears. And what fills that vacuum is never accountability. It's control. So the question isn't whether the system can survive a moment of real accountability. The question is whether it can survive without it. Because in the end, the true test of any democracy is not how it treats the powerless. It's how it restrains the powerful, especially when no one is watching.